What's the legal process for pursuing an injury claim in Kansas and Missouri? Hi, I'm Kevin McManus. I'm an injury attorney in Kansas and Missouri, here to answer that question for you. So the answer to that question could get very detailed very quickly, but let me offer you some general steps, an outline of process that we take in pursuing injury claims. And these general steps, there'll be probably a lot of action items that are contained in those that you can find on our website. But generally speaking, the first thing our office will do when we meet with a new client and after they retain us is to conduct a full investigation of what happened, who was at fault, what your damages are, what they may be in the future. And what that requires us is to gather things like accident reports, witness statements, medical bills, medical records, employment records if you're claiming lost income from the accident, and then gather all that information and really evaluate both liability, again, who is at fault, as well as damages. And from that information, we can then develop a strategy to pursue your case. And once we do that, often what will happen is we'll submit what is known as a pre-suit demand package to the insurance company of the at-fault party. And in that pre-suit demand package will be a lot of the information that we uncovered from our investigation. Again, laying out why their insured was at fault and what damages resulted from their negligence or reckless conduct. And again, that's going to have to lay out your medical bills and records and your condition both now and what it may be in the future, as well as lost income and any other damages that you may have incurred. Of course, we'll also be mentioning things like pain and suffering, if there's any permanency or disfigurement from the accident, and really trying to paint a holistic picture of both what this incident did for you, both now and what it will continue and how it may continue to affect you in the future. But that pre-suit demand package will go to the insurance company often, and they'll then have a decision to make. Do they make a settlement offer? Will there be negotiations, or will they not? Sometimes there isn't, and that's fine. And so what we do next is we file suit. And so what we do then is we file what's known as a petition if we're in state court, or a complaint in federal court that sets forth again what happened, who's at fault, and why you're entitled to relief or damages under the law. And so once that complaint or petition is filed, that opens and begins the litigation phase of the process. And what that means is now the case is on file. Of course, we want to be aware of timelines and deadlines like the statute of limitations, which is covered elsewhere on our website, and make sure that that case is filed promptly well before the statute of limitations runs. After a case is on file, the opposing party, the defendant or defendants, will have the opportunity to respond, and they can file what's known as an answer or other responsive pleading, setting forth any defenses they may have to the suit. And then after that happens, typically what happens is discovery, which is a phase of the lawsuit where both sides attempt to gather facts and information and documents from each other to understand and evaluate their case, what potential defenses there may be. We'll have the opportunity, for instance, to submit, and they will as well, written questions known as interrogatories, as well as requests for documents that they'll need to produce to us and we'll produce to them. They'll conduct likely depositions. We both will. We'll probably take the deposition of the defendant, and they'll want to take your deposition. There may be independent medical examinations from doctors to understand your condition, and other expert, depending on the complexity of the case, may be involved. All these things happen in the litigation phase of the lawsuit, and they really depend on the facts of your case and what issues are at stake. Along the way, there's always opportunities for the parties to discuss whether settlement is an option. Sometimes you may use a third party that's a neutral party, maybe known as a mediator, who both parties may agree to see if there's some negotiation or at least facilitate communication to see if settlement, again, is an option. So if there is no settlement, the case will proceed to trial, and in an injury case, our cases are tried by juries. So that, in a nutshell, is how you pursue your legal case on an injury claim. Again, you can find out a lot more information online on our website. The information is below, and if you have any other questions, please feel free to reach out and let us know.